Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of you, and they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Lovely people, another Saturday is here on BWTV, and we're bringing you The Community and the Law. So tell your friend to tell another friend to tell somebody left, right, front and back that we are live. And we're bringing you the very live discussion that will matter to you, especially when it bothers on your immigration situation here in the UK. My name is Oreku Frimpong, and doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we're looking at what your options are after receiving a UK immigration bill letter. UK immigration bill letter. Why? Have you been arrested for something? What have you done wrong? What it is that you need to do? How do you go about it? And the rest of it. And also, we shall be looking at one of situations of law, and we will be looking at a scenario, and I'll be asking you the question around that. And apart from that, we have the updates and all the bits that will benefit you. Once again, welcome to the community and the law, and is brought to you by BWF Solicitors. We're live on Facebook and YouTube at BWF Solicitors and at BWTV. Welcome on board.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and welcome to the show. It's the community and the law, and it's brought to you by BWF Solicitors. BWF Solicitors are located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. When you go there, they really listen to you. They help you go through your immigration issues. If they have to file an application, they have to file an appeal. If they have to give you an advice on all the issues. They do that so very well, and you are always having success with BWF Solicitors. And KSRI is testifying to that. And he says BWF Solicitors are truly God sent. From the very first moment, they were welcoming, compassionate, and highly professional. They handled my case with care, dedication, and excellence, giving me the peace of mind during a very difficult time. I'm truly grateful for their support, guidance, and commitment to justice. If anyone is facing any legal challenges, I strongly encourage you to run to BWF Solicitors. You will be in safe and capable hands. May God bless the entire team abundantly for the incredible work they do. KSRI writes that, and he's put that on our Google page where he's done on giving us the reviews. But if you would want to let us hear from you, you can visit any of our social media platforms at BWF Solicitors, X, Facebook, YouTube, TikTok, and what have you. You can call us on 0208 493 7340. Those of you in Ghana, there's an office in Accra, and you can reach them on 055 589 5959. 055 589 5959. In all emergency situations, call us on 077 127 61884. 077 127 61884. Visit our offices, as I said, on the fourth floor of Viana House, 214 to 218, Tottenham High Road, Seven Sisters, North London. We work Monday to Friday between 9:30 in the morning and 6 p.m. You can trust BWF Solicitors because we are there for you. We speak your language, and we are also very conversant with the law and what we do. A county court judgment, what is that? In simple terms, in the common person's parlance, we say CCJ. Now, a CCJ entered in default of debt may be cancelled if the defendant had paid the claim amount before judgment was entered. And it continues to say, quoting from the Civil Procedure Rule CPR 13, in other instances, if the defendant pays the debt in full within 28 days of the judgment, the CCJ must be cancelled. How do I know? How do I calculate the days? Who do I approach when it is that I have paid within the specified period and get it taken off my records? Then I may also ask, by extension, when it goes on my record, how long does it stay on there before it goes away? Because CCJ has a lot of implications, especially certain situations, and it might have immigration implications as well. So, ladies and gentlemen, let's welcome ourselves to the show and our resource person, Lawyer Charles Asma, to the show as well, because I know he would have something to give us on this one. Lawyer Asma, good afternoon.
Good afternoon, Bragoku.
How are you?
Very well. How are you?
Well, I am so very well, and I thank God for all the mercies that He's shown us. We are here and we're ready to get into the very deep end of the show. I have read this appreciation from Kay Asari, who is thanking BWF Solicitors. And he writes something that I find very interesting. He says, I strongly encourage you to run to BWF Solicitors. Seriously, we run, and when we come, we get a satisfaction. What would you say to Kay Asari?
Yes. Kay Asari is echoing what most people will not openly echo, but silently and within, they do believe that the place to go is BWF whenever you have any dire need for legal support or legal advice. And so this is a happy client. And here at BWF, what we do is to give you a cause to celebrate so that you can share a testimony. So we encourage everybody, just like Kay has said or done, that if you need help, of course, we're always available.
Okay, so with that assurance, and I think I need help. I'm talking about CCJ, County Court Judgment, that's passed against people who may go into debt and may not have paid over time, and the person who is pursuing the debt would send it to court. The Civil Procedure Rule says that, CPR 13 says that, when a judgment is entered in default of debt, it may be cancelled if the defendant had paid the claim amount before the judgment was entered. And the same CPR 13 says that in other instances, if the defendant pays the debt in full within 28 days of the judgment, the CCJ must be cancelled. So then How do I know when it was handed? Uh, s- it was made against me, so to speak. Um, Sometimes when a CCJ is entered and you want to even call the county court, you call and call and call and call lawyer. They won't even pick up. I don't know whether that court is a virtual court or whatever. So how do I calculate these ones? The 28 days and all the rest of it. Please help us.
Right. So CCJ, we know that is a county court judgment, and it's an important thing to most people, especially people in the UK, because your credit profile is linked to such data or court data. And the moment a judgment is entered against you on a matter of debt, it goes to your credit file, and in fact, it affects your ability to access credit. And we all need credit to survive. So within the CPR rules, what we call civil procedure rules, a matter will be raised by somebody against you.
Mhm.
You have time within the rules to respond, what we call the claim. So the complaint is the claim, and your response is the defense. Once a claim is made against you, you have time to defend. If the claim is made with all the information required, what we call particulars of claim, then you have 14 days to respond to the claim and to file your evidence.
Yeah.
If the claim is made but the detail is not added, then you have 28 days to file your defense. Either way, you have to file your defense. Let's assume that the person ignores the claim
Mhm.
or ignores filing defense. Then the rules say that if somebody, the defendant in this case, fails to file defense, the claimant can seek judgment in default. So the court will enter default judgment or judgment in default.
Mhm.
And once the court enters judgment in default, that is the end of the matter. Let's assume that you get to know later that the matter has been, a judgment has been entered against you, but you didn't know about it. Then within CPR 13, you can tell the court, I didn't know about this because I didn't receive the notices and I didn't have the opportunity to defend. And so we have to set it aside for me to have opportunity to defend. So we are starting all afresh.
Okay.
What if it's a case of debt? Now, let's assume that this person has received the information and on record, it is true that they owe the money, just that they didn't receive whatever information there is. If they had received it, it means they could have paid for it. So, having known that you a judgment has been entered against you, you check the date it was entered, and within 28 days, if you pay the money involved, the judgment will have to be removed from the court from the record
Okay.
so that it doesn't affect your credit file, for example. What if you don't and you respond or you pay for example, after 28 days, it will be recorded as satisfied, but it will still stay for the duration that it has to stay. How long will the judgment stay? It will stay on your record for 6 years. 6 years from the
6 years.
date, yes, from the date it was entered. How do you know the date it was entered? You
Yeah.
can get to know the date from the court record or from your own credit file. If you check your credit score, you see if a judgment has been entered against you, especially on CCJ grounds, and you know the date it was entered and the person or where it came from. And if you want to act, you quickly act within 28 days. And if you have already acted, but it hasn't been known, then you draw attention all within the 28 days. So you can calculate. So, for example, if it is today, 17th, then you have 28 days. If it is the next 30, the next month, then it's going to be, let's say, 17th of February. We come down 2, 3. So 15, 14 February. So if it is today, then you have 14th of February, for example, to deal with it so that it doesn't affect you. But if you don't do that and it goes beyond 28 days, whether you pay or you don't pay, it will stay for 6 years. What's the
So
implication?
if um, in my situation, I didn't realize it until after the 28 days, and I appeal, would it be heard? Because I didn't realize it. I may check my credit file once in every 6 weeks, and it does happen that somebody had sought judgment against me in that situation. Can I appeal against it?
And we said that you can so it's not a case of appealing it. It's a case of telling the court to set it aside because you didn't know. Why didn't you know? You have to tell the court. Is
Okay.
it that you moved address and so all the paperwork, all the notices, you didn't receive them? Because the rules are that one, you must be given the claim. You might be sent the claim,
The claim.
and the
Okay.
claim must come with particulars of claim, and you must be given time to acknowledge and file your defense.
Mm-hmm.
So if you didn't receive the claim, then you didn't have opportunity to defend the claim.
Right.
If you didn't have the opportunity to defend the claim and a judgment is entered against you, then that is unfair judgment.
Okay.
Or there should be justice and fairness. And so if you didn't have opportunity to defend, then court will listen. However, court will want to know whether there's realistic prospect of defending the claim.
Okay.
So realistic prospect simply means that if I had the opportunity, I would have defended. And if I had defended, I would have succeeded. In
Mm-hmm.
this case, the court must give you opportunity to defend. They will set it aside and start the whole process again. They will then send the notices to you and so on and so forth. What if you didn't know, you get to know now, and you realize that if I had known, I wouldn't still have been able to defend? Then there's no realistic prospect of success, even if you were to defend. Are you following?
Yeah.
In this case, you have two options. Either you accept to deal with it or you accept the fate as it is. So accepting to deal with this simply means that you will then say that I want to pay because it's country court judgment. I want to pay within the time frame so that I have my credit score protected. Or I don't really care. I don't care about credit score. Let it stay and to stay for 6 years. And within the 6 years, your credit will plummet to the lowest level. For example, bad. And if it is bad or worse, then of course, no credit provider will trust you with credit facility. But that is the credit side. But in terms of the court procedures or processes,
Mm-hmm.
if even if it is not affecting your credit, the 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 claimant can seek what we call enforcement action against you or against the person, the respondent. Enforcement action is where the person will go back to court and say, I want the money still paid. So I want it paid, and you have to then ask the court how you want it. That is why sometimes the person will seek bailiff to come to your address and collect your things. Or they will have what we call assessment of earning, assessment of earning, so that they will check your income and take it from source, and so on and so forth. So there are different ways of seeking enforcement of the debt or the judgment. However, if you clear it, you are okay. So if it's an individual, it will affect you. But if it's a company, of course, if it's a matter of companies, because companies are not directly linked to the individual, some companies will say, you know what, we are just going to let it be. But for this particular conversation, it's mainly about individuals. And as an individual, once you have the CCJ, you can deal with it within 28 days, or you can let it be and it will affect you for 6 years.
So if I find out, and maybe unfortunately the 28-day period had elapsed, and I ask the court to rule in my favor so that I can have a settlement or a payment plan? Is that allowed within this situation?
Well, once the matter a judgment has been entered against you, you have 28 days from the date the judgment was entered to pay in full, what we call full satisfaction.
Mhm.
Once you clear fully, you are okay. But if you don't clear it fully within 28 days, then you still have a choice to clear it after 28. Let's assume that you got to know about this after 28 days, then
Mhm.
it's too late.
Yeah.
Unless you are telling the court, I want to set it aside. But if you knew about it, then 28 days is too late. But if you didn't know about it, then the best way is to tell the court to set the judgment aside so that it is heard afresh, so that you have your opportunity to defend and maybe deal with the payment. That is
Okay.
if it's after 28 days. But if it's within 28 days and you know that you don't even have what it takes to defend it because the claim is true, then you might as well pay for it so that you have yourself, in terms of your credit score, protected.
A county court judgment, as we said, entered in default of debt may be cancelled if the defendant had paid the claim amount before judgment was entered. In other instances, as the Civil Procedure Rule CPR 13 says, if the defendant pays the debt in full within 28 days of the judgment, the CCJ may or must be cancelled. This one is not may, it must be cancelled. Okay, so let's get into this situation and scenario, and let's see what John would have as the best advice coming from you. So he checked his credit score on the 2nd of January 2026 and discovered that a CCJ had been entered against him on the 23rd of December 2025 for unpaid parking fine of £850. Now, John is worried that his credit will be affected for 6 years. So he has approached you for advice. What are you going to say to John? I've given you 3 options and scenarios. You can tell John that he can pay the debt and have it satisfied, but he will have to wait for 6 years for the CCJ to be removed from his credit file. Are you going to tell him that, John, you can ignore the debt because the CCJ may stay on your credit file for 6 years, even after payment? The third one is John should pay the debt within 28 days from the 23rd of December 2025 so that the CCJ can be removed immediately. Which will be your best advice to give to John? Think about that. I will be testing how well you understood the nugget explanation. I will be testing how you will be able to calculate the 28 days from the 2nd of January, probably backwards, and all the rest of it. It's all on the community and the law, and it's brought to you by BWF Solicitors. Now, this afternoon, what we are discussing is a very interesting one. What are my options after receiving a UK immigration bail letter? To the ordinary person, when we say bail, then it means that you have been accosted, arrested, and you've been given the chance to go report, and you made some conditions so you don't run away from the law in being pursued or you being pursued by the law, so to speak. Immigration bail letter. What does it say? What does it imply? And what the options would be? We'll be discussing this because fortunately we have lawyer Charles Asma from BWF Solicitors with us, and he will help us delve into this. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontestant divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. We're live on BWTV, and the program is The Community and the Law. And sorry, and it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. You can call BWF Solicitors on 0208 493 7340, or in Ghana 055 589 5959. Emergency situations 077 127 61884. This afternoon, they have helped us and pushed us again on BWTV, and we're coming your way with the discussion. And the topic is, what are my options after receiving an immigration bill letter from the UK Immigration Service, or whatever it is? Uncle Charles, what have we done wrong? Immigration, do they arrest people? What do they do? Why the letter? What do we do? I know I've put all the questions together in one, so I'll leave you to unveil and unravel that.
Thank you very much. So, viewers and listeners, this conversation is on immigration bill. The context is that anybody who does not have a valid leave to remain in the UK is automatically an overstayer. As an overstayer, the bill is inherent. It becomes clearer when they write to you to tell you that we know you are here without papers. And so we are informing you that being here without papers is a bill. And being on bail means that at any point in time, you can be asked to leave, especially when you are confronted. In other words, you are, I don't want to use the word arrested because they are not arrested per se. They are encountered. So once you are encountered by immigration enforcement agencies or authority, i.e. the border force, then you have to explain why you are still in the UK. That's the first thing. There are instances where somebody will be specifically told that they don't have leave to remain in the UK from a particular date, and that being here in the UK is a bail, and that they are being served with formal bail notice. And that bail notice is what we call Secretary of State bail. There is court bail and Secretary of State bail. So the Secretary of State bail comes from the Home Office to tell you that you are on bail because you are somebody who does not have leave to remain in the UK,
Right.
and you are here. And being on bail, these are the conditions of your bail. So we have given you time to remain in the UK, time to remain, not up to any point, but just to remain. We are not sending you away, but just to let you know that you have some conditions attached to the bail. And such conditions attached to the bail may be that you don't have to work or you cannot work. So even if you had visa that allowed you to work and it's been cancelled, because we are looking at you have somebody who has become an overstayer.
Okay.
Your visa has been cancelled or your visa has expired. Then, as an overstayer, once you are given bail, one of the conditions will be you don't have the right to work, because
Okay.
without valid visa, you cannot work in the UK. Another is that you may not have the right to go to school, and they will list certain things that you cannot do. The main one being work.
Okay.
And once your letter is sent to you with those conditions, then you cannot do anything apart from keeping to the bail conditions. One other condition may be that you have to be reporting yourself to the authority, i.e., the police or the immigration. Why the police? They refer you to the police station not on criminal grounds, but on immigration grounds. So when you go to police station and you report, you're only reporting to immigration officers who are attached to the police station. You go and you have to follow. Sometimes you have to report digitally online, sometimes on the phone, and other times face to face. But the point here is, once you have received this letter, what will be your options? Is that the end? Can you do something? And if you were to do something, what will what can you do? Now, having the immigration bill means that at any point in time, they can tell you that the immigration bill is no longer active, and so you are being sent away. So at any point in time, they can decide to remove you from the UK. Now, that is even if you haven't breached the condition, but the moment you breach any of the conditions, then that becomes even a serious matter for breaching a condition of your immigration bail, i.e., you are found working whilst you are told not to work. Then automatically you may be sent away or sent to detention to prepare for your removal to be escalated.
Lawyer, you said something. Maybe before you go on, you said that when the bail letter is given you, they may not send you away, but would ask you to be reporting to them from time to time. It could take X number of years, and they have not sent you away. In that situation, do you just always have to wait for them to take you away, or you can voluntarily say that I'm tired of you, I want to go to my country back, so I'm not reporting again, I'm getting on the plane to go away? Would that be an option? Is that what we're going to look at? Is that one of the things probably we're going to look at?
Yes. For the options, of course, you always have an option to stay or to go, and therefore it is an option. So once you've mentioned voluntary return, yes, that is something that somebody can consider. Sometimes, if you voluntarily decide to leave, they may give you money for fuel. Then you just go.
Oh, so they can pay for my plane ticket for me to go?
Yeah, sometimes, yeah, they have a package for those who want to go.
Oh, okay.
Yeah,
Right. Oh, that's nice because if I want to go to my country and pay my plane ticket, then that's
yeah. And
good.
you may even have change after paying the ticket. You may have extra
You may
left.
have extra to cater for
Yeah,
yourself when you go back to your country.
to start off when you get home.
Oh, okay, okay. Yeah, well, I won't go into the statistics because probably it's just me alone that is excited to go that way. Well, thank you. And it could take several years. So, how do they expect somebody who has bail conditions um, not to work, not to access public facilities, and the rest of it? How do they expect the person to exist and remain here when you have barred the person from doing all these things? Why don't they send you straight away if they think that you don't belong here?
Yes, I mean, on that basis, I think that the country or the government has a human face to some of these things, because yes, rather than asking the person. You know, some people get removal direction right away. Other people get just a bail opportunity to just relax and decide. Some people they have to fight for the bail. Other people they are giving the bail.
Okay.
Now, there are instances where somebody's application will be refused and they will have no right of appeal. If you have right of appeal, then you are not going to be given a bail because there's no point for bail. You still have to stay because right of appeal means that your case is still to be decided further. So if somebody makes an application, for example, and the application is refused and there's no right of appeal, the application will be certified under Section 94 of the Nationality, Immigration, and Asylum Act of 2002. And once your application, the refusal is certified, that means the reason you gave for which you sought permission to remain is unfounded, or is flimsy, or is untenable, or is not, it doesn't make sense. And so they are not going to give you a bail, they're not going to give you appeal right to waste court time with that flimsy excuse. So anytime the excuse or the reason you give to support your application is not good enough or doesn't make sense, they will certify your claim, be it asylum claim, be it private life claim, and so on and so forth. Somebody showed me a letter recently that they made a private life application whilst they were waiting to switch to other stuff. And decision came after almost 2 years. And it's been refused and certified. And the reason is that the evidence to support was not there, the private life claim, and that even the reason why they want to remain in the UK is nothing to justify why they want to be here. And so they were not given right of appeal. We know, for example, somebody who says, I want to make an application to stay in the UK on the basis of my private life. Private life, you have to be 20 years, or you must be less than 20 years, but with issues. If those issues, the reasons you gave for those issues are not clear or are not reasonable, sometimes I'm careful you saying
You
the
choose the
reasons are
words
not
closely, I
reasonable.
know.
If the reasons are not tenable, then they will certify the claim and tell you that your reasons are not something that can be justified.
Okay.
But so if somebody doesn't have an appeal right, automatically the refusal will come with a bail. As I said, the person who showed me their refusal letter, they also showed me their bail letter. And the bail letter was that you are now on immigration bail because you are somebody who does not have leave to remain in the UK. And therefore you can't do A, B, C, D, and so on and so forth. You were asking why would they be told not they can't do A, B, C? Yet they have allowed them to
To live
continue
in
to
the
stay.
country, yeah.
That is better than being told to leave immediately, isn't it? On a balance of on the scale of preference, most
Reference.
people would prefer to have a bail and to at least have a presence in the UK than to be told that go tomorrow or leave immediately.
Okay.
Right.
Uh, well, several thoughts are going through my mind, but for the purposes of this program, I'll leave it.
Right. Yeah. So that's that bit. So if you look at the context, what a bail is just notice to say that you are you can remain in the UK, but you are restricted because you are under immigration control.
Okay.
And it is given to people who do not have leave to remain in the UK because it is either expired or cancelled. And it is once you are given that bail letter, you are also given conditions that you must follow. Once you breach any of those conditions, it will trigger automatic removal. And so your job is to make sure that you keep to the conditions of your bail. Whilst keeping to the conditions of your bail, for example, reporting, can they send you away? Yes, it is possible. So we move on from here. What are your options whilst
Okay.
on bail?
What are the options whilst on bail? Ladies and gentlemen, I believe that you're getting your notepads, you having mental notification of all these things because we know that most people who are in a situation like this do not necessarily know what to do. It's not the end of the story. There's no full stop. There are certain things that you'll be able to do, and Lawyer Charles Asma, as has indicated earlier, is going to help us look at these options. It's all live on BWTV, and the program is the community and the law. You can reach us whilst the program is on. Send a text 07399208468, or you can leave that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Lawyer Asma, right after this short break, would be taking us through the various options. So let us hear from you. Put that down in the comment section, as I said, or send a text or WhatsApp 07399208468. When the time is up right after the discussion, I will activate the phone lines 0208 493 7345 for you to call in. Don't call in now because now is the time for us to really absorb what it is that we are discussing. So I'll show you my social media handles, and when we come back, the Axma will continue. Welcome back and thank you for sticking around. So, those of you who are with us live on Facebook and YouTube, I want to acknowledge you and thank you for sticking around. When you come in, you like the page and share as well. If you're new here, subscribe to the channel, click the notification button so that whenever we put content out, you will be notified and you will miss out. Tilly Duma, as always, is here. Thank you, Tilly. Thank you. Bless. We have Tilly also calling other people to come in. That's a very nice thing she does. So she calls people to come join us. Give you a Sedu Crunchy. You've been called, so please respond. Fred Amwai, Tilly's calling. We have Ritz Mametano. You are also being called. Michael Ba, are you here? Yes, I think so. Abna Obrewa Asante Papabi, Asantewa Papabi, welcome on board. Penelope Pinzo, you are also being invited to join us. Abigail Osemens, and good afternoon, everyone. Ade Safo has responded and also done his bit. We have Nana Kwame Obrimpon. You've been summoned to come to the class. Kindly share, comment, and like. Thank you. So those of you who have done that, thank you. Those who have not done that yet, thank you. Comment, like the page, and let the algorithm read so very nicely well. Lawyer Charles Asma is our resource person and guest from BWF Solicitors, our benefactors who sponsoring the show. And this afternoon, we're looking at our options after receiving a UK immigration bail letter. He's explained why you would be receiving such a bail letter. And I think the caveat here is if you are giving a refusal letter and a bail letter, then it means that you don't have the right to appeal and you would have to prepare yourself to leave the UK or wait for them to say, we are ready to take you away. One thing that excited me at the point was that, well, if I decide to go voluntarily, what would they do? They will give you a plane ticket and probably some change at the back of it. But that's not what we're looking at. It's one of the options. Anyway, what are the other ones? Last one.
Sure. What are the other ones? So we know that you want to remain. That's why you have opted to accept the bail and stick around. So while sticking around, you can make an application, human right application. Because once you don't have a visa, you cannot apply for student visa or work visa. So your only option will be human right visas. What are the human right applications that you can make?
Mhm.
Remember, I gave an example where somebody made a human right application, for example, private life, and the person has been refused and claimed certified because they are not 20 years in the UK, and so they couldn't have been able to apply if they don't have any reason or any case of being in trouble if they were to go back to their country. So for such a person, making another application, private life application, is not justified unless the circumstance has changed. So we are talking about human rights applications that you can put in. One, you can put in application as a parent. If whilst on bail, you become a parent to a British citizen, or whilst on bail, you become a step parent to a British citizen child. Not just British citizen child, but also a child with indefinite, or a child who has lived in the UK for 5 years and was born in the UK, or a child born abroad but has lived in the UK for 7 years,
Mhm.
or
So,
even,
so we technically, as sometimes you let us know, can we technically say that a qualified child should be a settled child?
yes, so a qualifying child, you have to be settled, of course, but being settled, because sometimes we get that term has now been attributed solely to EU visas.
Okay,
But settled simply means indefinite leave to remain.
okay.
So the child may have indefinite leave to remain,
Mhm.
or the child may have British citizenship, or the child may have EU citizenship with 5 years, or EU citizenship with indefinite. Or the child might have been born in the UK, no passport, but lived for 5 years.
Okay,
Born abroad, brought to the UK, has lived for 7 years. All these are options for that. These are attributes of the child that can help the mother or father to put in an application as a parent if they were to remain beyond the bail.
okay.
So for this, we know we have two aspects. I call one biological parent and the other step parent.
Mhm.
Biological parent, you are the parent. But if you are the parent and you have been given a bail, which is, let's say, 3 months old, bail letter 3 months old, I don't think you can become a biological parent within 3 months because it takes at least 9 months
Mhm.
for gestation to end in terms of human biology. And so, even if you are going to be a biological parent, that can take you close to 1 year. That is somebody who, so here we're talking about future option. But if it's not about future option and it's a medium or short term option,
Yeah,
it might be that this person has been in a relationship with somebody for the past 2, 3 years.
yeah.
And the person has a child who is British. And on that basis, this person who has this child has applied and is on 2.5 years leave to remain.
Okay.
This one who has been given the bail letter is already in a relationship
Right.
and living with the mother, the partner, i.e., the husband or the wife. Being in a relationship doesn't necessarily mean you have to have married. So if you have been together for 2 years, whether you are living together or not living together, you are in a relationship.
Mhm.
However, if you are not living together, then it's difficult to show that you play a role in the life
In the
of
life
that
of that child.
stepchild.
Mhm.
So to be able to show that you play a role in the life of the stepchild, you should be living in that family unit.
Okay.
So you become the stepmother or father, and your partner or yeah, your partner, or be it married or unmarried, becomes the other parent, which is the parent of the child.
Of the
Then we have
child.
the child in question here.
Yeah.
And on that basis, you can apply for leave to remain beyond your bail as a parent of a qualifying child, be it biological or step.
a step fine. Okay.
So there's a point here. Somebody may ask, how long should I be in a relationship with this partner for me to become a de facto step parent?
Mm-hmm.
That is 2 years. Living with a partner and a child, you are a de facto step parent. A de facto step parent simply means that you are not married, but you are in an unmarried partnership situation with that parent. And so by default, you are a parent to the child.
Okay.
Some people may not also be married and they may not also have been in a relationship for 2 years, but they just started living together in that relationship, and the person is looking after the child as a step parent. 2 years is not. There's no marriage. So what do you need? So where there's no marriage and where 2 years is not up to it, you can go to court and ask for parental responsibility order so that this other parent becomes a parent that has been given right by the court through the parental responsibility order.
Okay.
So that's also allowed. So when do you need parental responsibility order? Where there's no marriage, because you don't have marriage certificate, or you haven't been together for 2 years, then you go to court to give you the power to have parental responsibility. And having parental responsibility means that you can apply to remain with the child for whom you have been given parental responsibility.
Okay.
Somebody may be asking, so lawyer, what if I'm looking after my brother's child because my brother is not well, my sister's child, my sister is not well, or my church member's child? I do this, I do that, I do that. I literally play the role of a parent, even though I'm not a family member. Can I? The answer, the default answer is no. However, yes.
How?
How? Because in this case, you go to court and they ask for parental responsibility order.
Okay.
As a caretaker parent,
Mhm.
your parental responsibility order from court makes you a parent within the Children Act. Within the Children Act. And within the Children Act of 1989, a parent with parental responsibility is as good as step parent or biological parent. So that is also an option. So all this while we are discussing parent, biological parent, step parent.
Okay. So once you have that court order, for instance, and then you have been able to establish the parental responsibility, is it a given that you will be granted permission to change your condition to then be able to live in the UK either on a limited leave to remain or on any other route? Is it a given?
Right. Now, once you make an application, it has to be assessed by a caseworker.
Okay.
Caseworker will assess it against the rule under Appendix FM. Appendix FM, we have the 10-year route and 5-year route.
Mm-hmm.
5-year route says that you have to meet all the requirements, including immigration status. Now let's pause. We have established that for 5-year route, you need immigration status, right?
Meanwhile, this person doesn't have,
Why doesn't this person have? Good point. Why?
because the person's permission to leave was varied and was asked to leave, though not
The key,
yet
the,
left.
the key word for discussion, the topic itself, the key word is the B word, isn't it?
The bill.
The bail. Because the person is on bail.
Okay.
Being on bail simply means that you are close to nothing,
Mm-hmm.
but you've been given amnesty to remain anyway.
Okay.
Remaining for what? Remaining simply because you have to be physically around, but nothing else. So
Mm-hmm.
you're on bail. Anytime they can ask you to go.
To leave. Okay.
Yeah. So because the person is on bail, automatically there's no immigration status.
So then you
And
go in
because
10 years.
exactly, and because there's no immigration status, the person cannot make an application under the 5-year route.
Okay.
Because the 5-year route, you must prove everything, including immigration status.
Okay.
And if you are on bail, you don't have immigration status. So the
Okay.
question is, if I can't get under 5-year route, can I get it under any other route? Yes.
Yes.
So
Okay.
there are two gateways. Gateway one is the closed gateway, which is 5-year route with everything ticked. But gateway two is the 10-year route, which has some of the things not necessarily to be ticked.
Okay.
So what are some of the things that must not necessarily be ticked?
Yes.
One, immigration status is not necessary.
I'm confused here.
All right.
For the 10-year route, you're saying one of the conditions, you do not meet the immigration status condition because you are on bail.
Yes.
Um,
That's a 5-year route.
that's a 5-year route. But if you go on the 10-year route, immigration status does not become a requirement.
So what we are saying here is that 5-year route is everything on point. You have to
Mhm.
meet all the requirements. Tick,
Okay.
tick, tick.
Mm-hmm.
So there's no option here.
Mm-hmm.
It's not like bring some and leave some out. 5-year route. So if you don't
Okay.
qualify under 5-year route, then your option will be under 10-year route.
Okay.
Now, because it's a human right application and you are applying as a parent and you don't meet 5-year right because you don't have immigration status at this point,
Mm-hmm.
you can only consider the long journey, which is the 10-year route.
Okay.
The long journey says that because it's a long journey, you don't necessarily have to have everything that you need for the short journey. What don't you have to have? One, if you don't have immigration status, it's fine. Two, if you don't have English language requirement, it's fine.
Mm-hmm.
Three, if you don't have financial requirement, it's fine. But under the 5-year route, all these requirements are important.
Important. Okay.
What it means is that under the 10-year route, all you need is relationship, and what you do in the life of the child,
Of the child.
responsibility.
Okay.
So under the 10-year route, you are looking at the relationship with the child and the responsibility you have for the child.
Okay.
And because you are a step parent, you have dual relationship. Relationship first with the mother or father of the child, and relationship also,
with the child.
and that so that your relationship with the child is derived from your relationship with the other parent, isn't it?
Yes.
And because your relationship is derived, or we call derivative relationship,
Mm-hmm.
then having derived the relationship from there, you can then add on to show that having had a relationship with this child, I'm playing a role in the life of the child. So it's responsibility and relationship, RR. Once you have the RR, we then say that if this person is has a relationship with the child and is playing a role in the life of the child, and this role is good for the child, then if we remove the person from the life of the child, it will affect the role and therefore the child will suffer. True or false?
That's true.
And because of that, it will be in the best interest of the child for you to be considered so that you can continue to play the role.
So if you establish relationship, say for instance in the 10-year route, and it's being considered because of
The role.
the role you play and in the interest of the child.
Good.
Okay.
And that is why we say that you can apply as a parent. But this is not other parent, any other parent. It has to be a responsible parent
Yes.
whose responsibility helps the child. And without such responsibility, the child's life may be precarious.
Okay.
And such precarious life of the child may affect the child's well-being and development. And so if we are saying that we won't give to the parent, this parent who is playing a role, and we don't care about the child, then you are saying that you are making a decision without thinking about the child. And that would be a breach of Section 55 of the Borders Act of 2009,
Okay.
which says that in making decisions that affect children, it must be always the case that you consider the child first and nobody else.
Mm.
So if they're only going to consider the adult and say we won't give it to the adult, then what they are saying is that we don't care about the
You
child.
don't
But
care
saying
about
that
it.
you don't care about the child, you are breaching the law. And that is why we say that under 10-year route, as a parent, once you're able to prove that you have a role to play in the life of the child, be it your biological child or your stepchild,
Mhm.
then you are telling the caseworker to make a decision in the best interest of the child,
Of the child, not the adult.
not the adult. Because if it's for the adult can go to their country and live.
Mhm.
But if they were to go to their country to live, their absence will affect the role they play, which may affect the child.
Okay.
And so it is in the best interest of the child to be considered for the adult to remain. And that's why we say that where there's children, it's in their best interest for their parent to stay around for their sake. And that is why we say that such application would not follow the strict marking scheme.
Okay.
They follow the exceptional marking scheme. And the exceptional marking scheme is under paragraph EX1 and also paragraph Gen 3.2. EX1 is where the other parent, of course, we are saying that to affect the life of the child. But in Gen 3.2, they all live together. So both parents, be it the step parent or the biological parent and the child, they live together. And so if you decide that this man or woman should be removed from the UK because they are on immigration bail, it will affect the life of the child. And on that basis, the person will be considered to be granted 2.5 under Appendix FM, EX1.
Yes, we have established that if you have a bill situation on your head, you can decide to go voluntarily, or then you would want to establish that you have a relationship and a responsibility with a qualifying child, which lawyer has explained and giving us the threshold for a qualifying child. And then you can put in an application. That is one. That is two. I would want to ask, is there any other option that is open to a person in that situation, lawyer?
Right. So for this person, the only option will be an option that will support the case.
Okay.
And simply when they have had children based on whom they have to be here to look after.
Okay.
The other option is that whilst in the UK, beyond the bail, they have had 20 years continuous residence.
That's a very difficult threshold, lawyer. Very, very difficult. Because you're
But
asking me not to work. You're asking me to just stay afloat and produce myself anytime I'm wanted. And you stay for 20 years? How do the people survive that?
but it's possible that at the time the person was given the bail, they only had 6 months to 20 years.
Oh, okay. So you can use the amount of time you spent prior to having the bill to add up to what can count up to the 20 years. Is that possible?
Yes. Yeah, because we are saying 20 years in the UK, not after the bail, in the UK.
Okay.
So you've been in the UK, stuck around 18 years to 20 years, you are apprehended. You put in some application, it went. They came back and said, no, it's not justified. So you've been given bail to leave the UK. You've got 6 months to go. You cannot appeal. You stick around 6 months, 20 years, and now put in application under proper private life, PL 5.1A, which says that if you can prove 20 years continuous residence, you must be given 2.5. Can I apply? Yes. So we are not talking about people who have to wait 20 years because they've only been around for 2 years. Then you have a long way. But because it's a general conversation, it can cover anybody, including people who are close to 20 years. So for those close to 20 years, it's easier to get there. But those who are long way to 20 years or far away from 20 years, waiting for 20 years will not be an option. That would be future option. Now, some people are also brave enough to wait for 20 years. So that's future. Now, let's assume that, yes, you haven't, 20 years is not an option because you have maybe 15 more years to go, or 17 more years to go, or 18 more years to go. However,
that's quite a long time.
whilst in the UK, things have happened that border on your human right.
Okay.
Article 3, for example, where liberty restrictions, persecution are at play. So that if this person were to leave the UK and to go to their country, lifestyle changes may affect their ability to survive. For example, whilst in the UK, this person has adopted a new sexual lifestyle. So if their sexual orientation has changed, for example, then they can apply on the basis that if they were to be removed, it will affect their ability to survive because of their sexual orientation. Because the culture, the law, the religion in that country or those countries affect or frown upon such lifestyle or practice, and so they can't survive ordinarily. So there's hardship here. In this case, the person can apply under paragraph PL 5.1 B, citing hardship on the basis of sexual orientation. Or the person can put in human rights application, HRO, citing sexual orientation that is inimical to the practices or culture in their country. Or the person can also apply for humanitarian protection, what we call asylum, citing the case. But if it's about sexual orientation, it's also a reason to apply. But if it's anything else, let's say political persecution, religious persecution, or any other line of persecution, then in all this, you have to prove your case. And that is why if the case is not well proven, they will tell you that the claim is unfounded and the application decision may be certified as unjustifiable.
Okay. Well, I know that you are getting very comfortable with that, getting confident around it. You know what to do. I think the best thing for you to do, and I would advise that if you have any questions, approach your lawyer, and particularly I would advise that you approach BWF solicitors, and they will help you through that. We have looked at the options available, and I know that definitely you may have a question or two to ask lawyer Charles Asma, who's right here with us. Thank you very much, BWF solicitors, for supporting us to bring this very educative program to our dear friends on the other side. BWF solicitors, you can reach them on 0208 493 7340, 0208 493 7340. They are on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. If you're driving, the postcode is N154NP. If you're using public transport, I would advise that you get onto the Victoria line, get off at Seven Sisters Station, use exit number 2. Exit number 2 will bring you to the frontage of the Anna House. Climb up to the fourth floor and you meet BWF solicitors. They work Monday to Friday, as I said, 9:30 in the morning to 6 p.m. in the evening. Those of you in Ghana, there's an office in Ghana where you can access the services of BWF solicitors. You can call them on 055 589 5959, 055 589 5959. In all emergency situations, you can call 077 127 61884. And if you want to reach out to Lawyer Charles Asma, who's our resource person and guest, taking us through all the various particular steps and the strategies around it, you can call Lawyer Asma on 079 47 636037 079 47 636037. That's the number on your screen there. Earlier on, I took you through the nugget and I explained, with the help of Lawyer Asma anyway, we explained the county court judgment situation based on the Civil Procedure Rule CPR 13. A county court judgment entered in default of debt may be cancelled if the defendant had paid the claim amount before judgment was entered. In other instances, if the defendant pays the debt in full within 28 days of the judgment, the CCJ must be cancelled. Lawyer Smith explained how you can go about it on the rest of it. But then I had our friend who had a scenario and wanted some advice. Let's look at what the situation was. John is the person I'm talking about here, and he checked his credit score on the 2nd of January 2026 and discovered that a CCJ had been entered against him on the 23rd of December 2025 for unpaid parking fee amounting to £850. He's worried that his credit will be affected for 6 years. Advise, John. Help me. One, would that be correct? Anyway, John can pay the debt and have it satisfied, but he will have to wait for 6 years for the CCJ to be removed from his credit file. Is it that we can say John can ignore the debt because the CCJ will stay on his credit file for 6 years, even after payment? Are we also going to say John should pay the debt within 28 days from the 23rd of December 2025 so that the CCJ can be removed immediately? Think of these, ponder over that. And also, if you have a question to put to Lawyer Charles Asma on the discussion we have had this afternoon, you can call in 0208 493 7345, or you can send a WhatsApp or a text message to 07399 208 468. And you can also leave that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and BWTV. Let's say thank you to BWF Solicitors with this message, and when we come back, we get on to the interactive segment of the show. Lawyer Asma is still around.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. As I mentioned, yes, we are now getting into the interactive stage where you can bring in your question. I mentioned earlier on that Lawyer Charles Asma is still with us and is ready to take your questions. So put them in the comment section down below on Facebook and YouTube at BWF Solicitors and at BWTV. You can also call. The lines are active now, 0208 493 7345. 0208 493 7345. Or you can send a text, WhatsApp message, audio note to 07399 208 468. 07399 208 468. Lasma, let's assume that this person has a bail condition on their head, and there has been some exceptional circumstance. I don't wish any ailment on anybody, but then the person probably has developed an ailment that may need specialist treatment here in the UK. Can they base or stand on this exceptional circumstance and put in an application?
Yes. So they can do that. There are instances where people can apply based on what we call outside the rules application, leave outside the rules. With leave outside the rules, what you are saying is that you don't meet any of the rules, but they have to consider your context and allow you to stay.
Mhm.
That is pure discretion.
Okay.
Or you apply under paragraph PL 5.1B of Appendix Private Life to say that I want to apply based on my limited time. However, because I don't have all the 20 years, my situation is such that if you remove me from the UK, I cannot get the care and support I need based on this critical condition. And this is the evidence I have. And so consider me under the exceptional rules circumstance. So here we are also looking at, for example, paragraph Gen 3.1. And Gen 3.1 will take us into other exceptions where, for example, 1B will talk about where there will be hardship and the person through the hardship cannot survive in their country of or home country, then they have to be considered. So from the scenario you have narrated or the story you've told, the fact pattern suggests that if there is element of hardship and it is proven, then it is a basis for the person to be considered either on discretionary grounds or under private life grounds with hardship.
Okay. Well, let's see some of the questions people may have brought for address, and let's also advise that people send in their texts and WhatsApp messages to 07399208 468. Afia says, I went for my biometrics and they just scanned my passport. Should I be worried?
Is that so? That is a fierce. If a fear was around, I was going to ask if what were you expecting? Yeah, when you go for your fingerprint, they will scan your ID, scan your face, scan your fingers, and that is what we call biometric enrollment. So if they scan your passport, I don't know whether they gave the passport back to her, but even if they gave the passport to you, fine. So if that is all they did, then it should be fine. Okay. But maybe There's something else you don't want to tell us, or you haven't told that. Please, I went for the finger biometric, and they just scanned my passport. Did they scan your face and fingerprint? Just your passport? If you come again, did they scan your face? I mean, take your picture and did the fingerprint. If they did, that is the biometric enrollment. But if they just scanned your passport, then there's something they didn't do.
Okay. Well, let's pick up another one that we have here, and which is Kojo Boateng is saying that I owe HMRC pay debt, and I've been paying monthly bit by bit voluntarily, but having had an arrangement with HMRC. I have applied for citizenship. Can they refuse this application?
Well, so one, Kojo got the account details to make payment, right?
Mm-hmm.
And two, the account details might have been provided by HMRC.
Yeah.
So the fact that Kojo is making payment towards clearing the bill, and HMRC hasn't said that pay everything at once, presumption is that they have accepted the voluntary payment. And the fact that it's not on paper still makes it an arrangement anyway, because you have elected to pay by installment and they have accepted your installment payment. And there's nothing to suggest that you have avoided responsibility. And there's also nothing to suggest that they have not accepted your voluntary payment. And that means that you are paying the debt, and that will not be a suitability matter.
Okay. Well, Kojo, I think that you are doing the right thing by paying. If you don't pay, then you kind of worsening your case. So go on to pay and heed to the advice that lawyer has given you. Yes, keep them coming through. Please, is exercising treaty right of an EEA spouse part of retention of right application? How long does it take for a retention of right application to get a decision?
Right. It's not by exercising treaty right. So retention of right means that something has happened that has affected the relationship you have with your EU national family member. And that is either death or divorce. So under the EU regulations, Regulation 10 especially states that when there is what we call supervening event, i.e., death or divorce, even though it affects the relationship with the family member, it doesn't affect the right that was there before that event happened. And so you can make an application as before, using divorce to represent the marriage, and also using death certificate to represent death. You still have to show that you have lived 5 years in the UK before making the retention of right application. Otherwise, you will only be granted 5 years, but still under retention. So retention means I'm applying for EU visa in the UK without my family member because there's either death or divorce that has separated myself and the family member. Of course, that family member before death or divorce was a EU national exercising treaty right, and that right affected your right as a family member, and that by enjoying that right before death or divorce, you continue to enjoy that right, hence retention. As to it says, how long will it does the take retention to get a decision? Well, I don't know when you made the application, but it can take a longer. But we don't call it retention application. There's nothing called retention application. It is still EU application for either 5 years or indefinite. But you applied on the basis that you have retained your right. So it's the category, not the name. So I don't like it when people are making retention of right application. You are making an EU application on the basis of your retention right.
Of right.
Yeah. So
Okay.
I like it
Yeah.
that way. Normally, people would think that, okay, I'm going to make retention application. Why? Because we are divorced and it's 2 years now, but you haven't even been here for 5 years and you want to apply for indefinite simply because somebody has said that there's something called retention of right application. No, there is EU application based on retained right. That is how we put it. But this person, it can take 6 months or less than 6 months we all or longer than 6 months. We don't know how long it will take, but eventually a decision will be made. If it's taking too long, they can follow up.
Well, keep them coming through. 0739920848 is for text. Um, Comment section on Facebook and YouTube at BWF Solicitors at BWTV UK. On Facebook, we have Sir Ajay Ankuma. Can my son, who will turn 18 this year, come as my dependent and stay? He visited me last year.
Of course, if your son is joining you, they can, depending on your circumstance. If your son is joining you, we want to know where the father is. If the father is in the UK with valid visa, not visitor's visa, valid settle a visa leading to settlement, and you also have a visa leading to settlement or settled visa, then of course your son can come. There will be no issue of sole responsibility. Or you came as a spouse to join your husband, which is the son's father, and you are living with him. Your son can join as a child joining the parents. But if the other parent, that is the father of the child, is in the country where the child is, then you have to show sole responsibility, or you have to show that the other parent is dead, or you have to show that if the child is not allowed to relocate to the UK, they will suffer incurable hardship to life. That is serious and compelling family circumstances. That makes the exclusion of the child from the UK undesirable. And so, under paragraph 297 of Appendix FM, you will be making the application for your child depending on the circumstance, either as a single parent or if or as a shared parent with shared responsibility. But the assessment will be based on where the other parent is. And so, it's a whole package of rules that you have to understand before attempting an application for your child. If your child is turning 18, put in the application before the 18th birthday. The decision will come after they have turned 18. However, because they applied before they turned 18, it doesn't affect them.
Keep them coming through. Last month here to help us. I remember I have my scenario to get you to answer for me. So get them to us as soon as you can. The options are 1, 2, and 3. We'll be looking at that very soon. But let's keep taking your comments and questions. If the new immigration proposals come to law, it will not affect EU nationals. What of EU family members?
So it is EU nationals and their family members.
Okay. So that distinction is not made. Is EU nationals and their family
So
members.
this person is saying that he knows that it will not affect EU national. What about the family members? And I'm saying that it also includes the family members. So EU nationals and their family members are not affected by the new proposal.
Okay. Eminence Ventures, thank you for your question. Let's pick the next one. This one says, please, is excising treaty part of the retention of right? I think we answered this one. So let's thank you for that. Those on 10-year parent route who want to switch to 5-year route, what level of English language do they need?
Right. So under 5-year route, the default position is A2. But I would say that if you can do B1, just go get B1 done. But it's mainly A2. Or if you have English language, you have degree taught in the UK, that's also acceptable. Or
Okay.
you have degree from abroad, but it's been converted by UK ECTIS to UK standard, then that's also fine.
Nanette, thank you very much. That's your answer to the question you posed. Harpreet Singh. Harpreet Singh. Good evening. I've got indefinite leave to remain recently. I applied for British citizenship, but I've overstayed. Um, I don't know whether, lawyer, you can make meaning of this question.
I got indefinite leave to remain recently. I applied for citizenship, but overstay. All right, so this person is saying that I have applied for British citizenship after my indefinite, but at a point in time during my stay in the UK, there was an overstay window. Would this affect my British citizenship? Now, what the rule says that from the 10th of February 2025, it says that suitability will be applied if the person entered illegally, not an overstay. So if you came legally and you overstayed and eventually got your 2.5, got your indefinite, and you're applying for naturalization, you are super cool.
Okay. Preet, thank you for that. Keep them coming through. The text lines are active, the landlines or the telephone lines are active. You can call in. This afternoon, we have discussed what our options are after receiving UK immigration bill letter. Lawyer Chasasma has graciously taken us through the discussions and giving us our options. But it's time for us to get interactive. So let's see what the next one is. Ojo. Ojo says, is a child British, though they haven't been registered yet after settled status? Is a child British as such? Lawyer.
So stay there for me. Let it stay. It says that is the child British, though there hasn't been registration yet after settled status. So let's assume that all the information here apply to the child. So the child has settled status, right? Or the mother that has settled status, or the father. We are not sure. Ojo, there are gaps because a child can only be British. So let me define a British child. A British child is a child born to a British parent or a parent with indefinite leave to remain. So a British child is a child born to a British parent or a parent with indefinite leave to remain at the time the child was born. So if the child was born and later the parent had settled status, then the child must be registered. So because you talked about registration, the child has not been registered yet. If the child has not been registered yet, then the child is not yet a British child.
Okay.
Registration simply means you are registering the child to become British. Because if the child is already British, registration is not necessary.
It's not necessary. Well, we will take just about a couple and then we'll come back for the sake of time. Keep them coming through. Let's see. Lawyer, if somebody gets a text message like this one, what should the person do? Your next
Okay.
reporting appointment is on the 19th of January 2026. You are required to attend to Ruskin Square. If you do not attend appointments without a valid reason, you may face penalties. Please refer to your Bill 201 document, which will confirm your reporting frequency. If you'd like assistance to return home, then please contact the Voluntary Return Service helpline on the number given or visit their website as given here to find out more and apply online. If somebody receives a text message like this, what does it imply?
It implies that the person is being reminded that their next appointment date is on the 19th of January 2026. It means they already know that they are on bail and that one of the conditions is reporting themselves. And so one of the dates is 19th and it's coming up. So just a polite reminder. What they must do is to go and report. Unless they are not well, then they have to call them to say that on the day of the reporting, That's the 19th. If they are not feeling fine, they have to tell them they are not feeling fine so that the appointment can be rescheduled.
Let's say look at the situation where um, the person probably must have been reporting, as you say, in the next appointment date. But between the last appointment and this current one that's coming, the person has met some condition for them to have the option that we discussed this afternoon. Should they still report? Or once they have an application probably pending, they should be okay?
That's a good question. It is good because somebody will think that once I put in an application following my bail letter,
Mhm.
I don't have to keep to the conditions of my bail. Now, somebody who is not with valid visa is an overstayer. An overstayer will be given actual bail or inherent bail. Inherent bail is where you're already in the system and informally they can they can detain you and remove you. Or formally, they've given you a letter which tells you what the conditions are because you are hanging around. Now, this person has been receiving the letter. The person is keeping to the conditions. The person has made an application based on their parental responsibility with their stepchild or their own child, and so on and so forth, or their private life, what have you. At that time, having an application pending means that they cannot be sent away. Because the law says that if you have a pending application, you cannot be removed from the UK no matter what, because you are waiting for a decision. So that will lock the potential for removal. What it means is that the person hasn't gotten it yet because we don't know whether they will be refused or granted. So that is not a basis to say, I am now free. Is the person free yet or not?
There's no decision on the application, so
And
obviously
so
they
they
still
are
have
not
something to
free.
stand like that.
And so they are not free. And if they are not free, they cannot say that they are now stopping to follow the bail condition.
Mm-hmm.
So they have to continue to keep to the bail condition. But at least they have assurance that no matter how many times they go, they can never remove them because they have application pending. And that gives them at least some energy to report because they know it's just a ceremonial process.
Hmm. Energy to report. It might be a ceremonial process. Whatever your questions are, you can keep them coming through. But we're going to, okay, Flora Adomabeko, we will take yours quickly. And when we come back, or right after the answer, we'll take a quick break, come back to our quiz question, and then we summarize our discussion for this afternoon. Can you apply for a skilled worker visa when you have a pending appeal on Section 3C?
So there are technicalities here, especially where you have appeal pending or administrative review pending. If you have administrative review pending, you cannot make a skilled work visa application. The same way, if you have appeal pending, you cannot put in skilled work visa. You can put in human rights application, but skilled work you cannot. Because at the time of skilled work visa, technically you don't have a visa because your visa application has been refused. And now you are challenging the decision. Whilst challenging the decision, you cannot change it to a skilled work visa application. If it's a human right, yes, you can, because human right, in terms of 3C and all that, there are some flexibilities. But with skilled work, it's quite strict. And so, my sister, if you are if your appeal is pending, and you have sponsorship certificate to switch to skilled work visa before the decision is made, even though you have varied application, they are going to use technical argument to refuse the application.
Okay. Well, Flora, thank you very much. So those of you right there with us, we taking a quick break, as I said, and when we come back, we'll be looking at our quiz, And then lawyer Charles Asma will help us with the right answer, the correct one. And then we summarize and draw the curtains down. It has been the community and the law brought to you by BWF Solicitors. And we're live on Facebook and YouTube at BWF Solicitors and at BWTV. Welcome back, and thank you very much for sticking around. If you've stayed with us from the beginning to now, I think you deserve an award, and you deserve to also like the page and share it as well. What are my options after receiving a UK immigration bill letter is what we have discussed this afternoon. But then earlier I mentioned and quoted something from the CPR 13. And what I said was that a county court judgment entered in default of debt may be cancelled if the defendant had paid the claim amount before judgment was entered. And I also said that the Civil Procedure Rule 13 gives the option that in other instances, if the defendant pays the debt in full within 28 days of the judgment, the CCJ must be cancelled. So then my friend John came up with this scenario. And John said that he checked his credit score on the 2nd of January 2026 and discovered that a CCJ had been entered against him on the 23rd of December 2025 for unpaid parking fine of £850. He's worried that his credit will be affected for 6 years. Can John pay the debt and have it satisfied? Let's advise him. 1, John can pay the debt and have it satisfied, but he will have to wait for 6 years for the CCJ to be removed from his credit file. 2, John can ignore the debt because the CCJ will stay on his credit file for 6 years even after payment. And 3, John should pay the debt within 28 days from the 23rd of December 2025 so that the CCJ can be removed immediately. Which one is correct? Now drop them in. Let's see what answers you have. Priscilla says number 3, John should pay the debt within 28 days from the 23rd of December. Kevin Yabua also thinks it's number 3. Next one we have Anita. Anita thinks John can pay the debt and have it satisfied, but he would have to wait for 6 years for the CCJ to be removed from his credit file. Prince Saki thinks it's number 2. Ignore the debt because whatever it is, even if you pay, will stay there. So forget it. The next one from Samuela Samuas is for number 2. Thank you, Samuel. We go to the next one, which is Jessica Boadus, and she says it's number 3. Thank you, Jesse. We go to Millicent Ofosuhne. Millicent says number 2. We go to the next one, which is from Ernest Ado. Ernest thinks it's number 2. John, ignore the debt because CCJ will stay on your credit file. Anita Usu also says that is number 1. You can pay the debt and have it satisfied. But you'll have to wait for 6 years before it is removed. Mambwatma says it's number 2. John can ignore the debt. Tilly says it's number 3. Okay, so let me now see what lawyer Charles Asma thinks of my scenario and the options I gave people who were to give advice to John. Uncle Charles.
Cool. Now, this one, we are going to do it together.
Oh, no.
No, don't worry. We'll do it together.
Okay. No worries.
Go to the scenario, the nugget first.
Okay. So, can you take me back to the nugget? Yes. A county court judgment entered in default of debt may be cancelled if the defendant had paid the claim amount before the judgment was entered. In other instances, if the defendant pays the debt in full within 28 days of the judgment, the CCJ must be cancelled. And this one's from the Civil Procedure Rule CPR 13. Yes.
So now our aim here as advocate for John is to water down the issue for him, aren't we?
Yes.
Yeah, so we are seeking to water down the issue. All John wants is something that will make him happy. So, but the law says that if John can do something, then he will be happier.
So if he can pay within 28 days of when the judgment was passed, then it would be removed, or it must be removed. In fact, that's what
yeah. So if John can do that, then John will be okay. So if you are telling John what to do, will you tell him to ignore? Will you tell him to forget it? Or you tell him, Master, since you want to be safe so that you can go for more money from the bank and you need your credit score intact, will you? And the law says you can do something. What is it that he can do?
He can pay.
So what advice are you going to give him?
Okay, these options say pay, but maybe I would have asked him to go for a settlement plan.
What does 3 say?
Number 3, I would have asked him to go for a settlement plan.
All right. Well, 3 says that if he can pay within 28 days, then he will be free.
Yes.
Yeah, and then the CCJ will be removed. So as an advocate for John, you won't tell him to ignore, because ignoring means that to affect him for 6 years.
No, I won't tell him to ignore.
John can come back and tell you that, but lawyer, you told me to ignore, and I ignored, and now I can't even access credit. But I went to another lawyer, and the lawyer told me that if I had done something within 28 days, this problem wouldn't have persisted. Yeah. That means he gave wrong advice, because the law is clear that he could have done something within 28 days. And therefore, the good advice to John would be do something within 28 days from 23rd. Pay the debt.
Okay, so let me do some calculation here. 23rd of December, and I'm calculating 28 days from then. Let's see if it's within the period that he saw that the judgment has been slapped on him. So 28, 23rd, 24th, 25th, 26th, 27th, 28th, 29th, 30th, 31st. January 1, January 2. That's just about 10 days. So he's within the 28 days. John, go and pay, please.
Yeah, he's got 18 more days to go, right?
Yes.
To go borrow money to pay. Yeah. And that's the best advice under the circumstance for our client.
Lawyer says, and I think I agree with him because I've done the calculation myself as well. Listen, don't wait for 6 years. Don't ignore. Pay. And it's within the 28 days. So you would have it removed, because the second part of CPR 13 says that if you pay within the 28 days, it must be removed. Not it may be removed, it must be removed. So if John chooses to pay that, the CCJ will be removed from his credit file because the debt would have been paid on time. Thank you very much. Laya, you're making me a smart person, I know. Thank you so very much for
the whole essence of law is sociology, isn't it? It's a human, we call it what was that? Social science.
Okay.
And the social science is that there is issue and there's solution prescribed within the rules. And your job as an advisor is to look at the solution within the rule and look at what is best for your person. If the person, for example, came and told you that, you know what, I know I can pay within 28 days, but I cannot afford, and there's no way I can get the money, what should I do? Then you wouldn't tell him to pay and still have 6 years. You tell him to ignore. After all that be die.
Well,
so it depends on the circumstance of John. We could have said that ignore. After all, if you pay, you lose, you won't have it. If you pay, you have to wait for 6 years. If you don't pay, you have to wait for 6 years. So if you don't have the money to pay, then you might as well ignore, isn't it?
Yeah.
Well, he doesn't have the money. So we then tell him that if you can find the money, then pay, so that you don't have to wait for 6 years to clear the dent.
Okay. Well, Other bit was about the bail condition that was slapped on people from the Immigration Service or the Secretary of State for Home Department. And you gave us some options, and that formed our discussion this afternoon. Can you please summarize for us?
Sure. So, ladies and gents, viewers and listeners, today we looked at what to do once you have immigration bail. Immigration bail is given to people who have become overstayers, and Home Office is aware. They will be given the bail with conditions that may include no right to work. And if you are caught working, that will be breach of the bail conditions. The bail will normally come in a form of a letter. And once you are served, you have to read the conditions and keep to the conditions. Some of the conditions may be that you have to report to the immigration reporting center or to the police station. You have to keep to that. But whilst we are going through the bill or keeping to the conditions, can you do something? And we said, yes, you can. What can you do? Because you don't have a visa already, you cannot make any other application apart from human right application. And to make human right application, you are relying on your family life or your private life or some other hardship that may affect your ability to survive if you were to be removed. And so we are looking at Article 8 and Article 3 of the Human Rights Act and also the European Convention on Human Rights. And so you can apply as a parent to remain. You can also apply and on the basis of your private life. You can also choose to apply based on human rights under asylum protection or on what we call HRO, human right application based on your private life. Please, you cannot apply for for student visa. You cannot apply for spousal visa, and you cannot apply for work visa or skilled worker visa. And therefore, if you did any of those things, because you don't have immigration status already, the application will be refused. Your best bet is to apply based on human rights, based on parental relationship with their child, or based on your private life situation where hardship may affect your ability to survive elsewhere if you were to be removed from the UK. All this can be done. And whilst a decision is being considered or you are waiting for the decision, you continue to keep to the bail conditions. What you have to remember is that whenever you are on bail, or whenever you have an application pending as an overstayer, you cannot, the word is cannot, you cannot be removed from the UK whilst a decision is pending. But you must keep to the bail conditions until you have received a favorable visa decision that removes the restrictions from you. This is the conversation that we have had for today. Thank you.
Well, thank you very much, Lawyer Charles Asma. Thank you, BWF Solicitors. Thank you for staying tuned and thank you for contributing as well. We believe that your questions were rightfully answered for you. If you need any further clarification or you have any further questions or support with your immigration matters, especially, or any legal issues, speak to BWF Solicitors. We're located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And they also empower us with a program like this one, the community and the law, which comes your way every Saturday afternoon between 4 and 6 p.m. UK time. Today has been another one for us, and the opportunity has been well taken. And based on that, we're inviting you to join us same time next week for another one. So I want to say my thank yous once again on behalf of the production team, made up of Professor Ade, the producer, Sheila Krempat Modutu, of course myself, Uriku Frimpong. Good evening.